Hello, everyone. This is Lisa Parker, a member of Husch Blackwell's higher education team. I'm located out of our Chicago office and focus my practice on counseling and representing educational institutions in the areas of accreditation, regulatory compliance, risk management, litigation, and student-related concerns. Today, we will be talking with you about what federal higher education policy might look like under President Trump's new administration. Although we regularly offer webinars, we are excited to broadcast this webinar for the first time from our Chicago office. Before we begin, I'd like to cover a few housekeeping items. At the bottom of your audience console are multiple application icons for your use during the program today. I'd like to take a minute to highlight a few of the key icons for you. If you have any questions during the webcast, please submit your question via the question box. We will try to answer all questions during the webcast today, but if a fuller answer is needed or we run out of time, it will be answered later via email. We truly do appreciate all of your questions and audience participation and encourage you to submit questions. There is also an icon to assist you with your viewing preferences. Accordingly, please note that you can expand your slide area by clicking on the Maximize icon on the top right of the slide area or by dragging the bottom right corner of the slide area. If you have any technical difficulty, please click on your yellow Help icon. It has a question mark and provides information regarding common technical issues. A copy of today's slide deck and additional materials are available in the Resource List icon that looks like a green paper at the bottom of your screen. This program has been approved for Colorado, Illinois, Iowa, Kansas, Missouri, Nebraska, Tennessee, Texas, and Wisconsin for continuing legal education credit. A recording of the webcast will be available tomorrow for watching and sharing, and once available, a link to the recording will be emailed to you along with your certificate of attendance. The recording will be available for 2 weeks after the webinar. So now that those housekeeping items are out of the way, let's talk about who will be speaking today. So joining me today is John Burkowski, Tom Klein, and Julie Maselli. All of us are members of the Husch Blackwell Higher Education team. John has represented public school districts, colleges, and universities, as well as other nonprofits and businesses in the education sector for nearly 3 decades. He understands the practical, legal, and policy issues facing education institutions at all levels. Tom spent 27 years in the Office of General Counsel at Northwestern University, including the last 15 years as the university's Vice President and General Counsel before joining Husch Blackwell. Previously, he served as General Counsel and Chief Operating Officer for the National Association for Home Car, a trade association based in Washington, D.C. Julie's practice is dedicated to serving private and public institutions of higher education on a number of different issues. Before joining Husch Blackwell, she served as the Deputy General Counsel for Higher Education and Federal Student Aid at the U.S. Department of Education, and prior to that, as the Chief of Staff and Special Counsel to the General Counsel for that agency. So now we'll talk about what today's agenda will include. We will start off with an overview of key issues that will be discussed by Tom. Julie will then talk about the Trump administration transition. Then John will talk about the Office for Civil Rights. Julie will then touch upon a variety of regulations, including DACA and the HEA reauthorization. And then I will round it out with a discussion about accreditation. I'll now turn it over to Tom Klein.
Thank you, Lisa. First of all, I'd like to add my own welcome to all of you who have joined us for this program today. We have a lot of slides to get through and only an hour to do it. So I'm going to take it upon myself to try to set a brisk opening pace. I want to touch on a few key issues from a 30,000-foot level, and then I'm going to turn things over to my colleagues to get into some of these in more depth and to explore a couple of additional issues that I will leave to them to introduce as we go along. So we've called this session Reading the Tea Leaves, and the first thing to know about that is that reading of tea leaves is always perilous. The shapes we think we see may or may not actually be there. In this instance, it's actually even harder to read the tea leaves because there are so few leaves to read. Candidate and President-elect Trump made very few pronouncements on the subject of higher education. He has no record of public service. He's often made position statements that contradict some of his earlier remarks, and he's really provided very little indication on what he has planned for higher education. Betsy DeVos, who is his nominee for Secretary of Education, likewise has no background in higher ed, and at her confirmation hearings, she showed some gaps in her knowledge of some of the higher ed issues. So in trying to determine where things may go, we took a look at the Republican Party platform, which devoted less than 200 words to the topic of improving higher education. And that's not a whole lot, but let's begin there. The Republican platform acknowledged the excellence of America's colleges, universities, and trade schools. But the platform went on to say that excellence was being undermined by what the party called a deeply entrenched ideological bias that fuels political indoctrination. The platform calls on elected officials to preserve public colleges and universities as places of learning, and said, in contrast, not as zones of intellectual intolerance or safe zones. And as we all know, the concept of safe zones, sanctuary, and other issues of similar type have been under discussion at colleges and universities for a while, but never more so than in the last few months and year. Part of the platform quotes a little bit inaccurately the famous line from Tinker versus Des Moines School District, where it says, a student's First Amendment rights do not end at the schoolhouse gates. Colleges, universities, and trade schools must not infringe on their freedom of speech and an association in the name of political correctness. So I think we're going to need to look closely at how the Department of Education might weigh in on campus clashes over free speech and political correctness, bearing in mind that the putative secretary has been a significant contributor to FIRE, the Foundation for Individual Rights in Education. And just 2 days ago, on the day, or 3 days ago, on the day of President Trump's inauguration, FIRE reached out to him with a letter focusing on certain key issues in FIRE's agenda, including speech codes, the December 20th Dear Colleague letter, and various other issues. So that's something to keep our focus on. Another question that I think we all need to think about is what happens the next time we have an affirmative action case. Back in June, the Supreme Court upheld the consideration of race as one factor in college admissions decisions in the Fisher versus University of Texas case. As you know, that decision was made by a court that was missing the strong voice in opposition to affirmative action of the late Justice Antonin Scalia. So a question for us to keep in mind is, what will the court look like when the next case challenging affirmative action makes its way up for consideration? Justice Kennedy had appeared ready to move away from affirmative action in the Michigan cases back in 2003. He wrote an opinion for the majority in the Fisher case, but it's hard to know where he will come out the next time around. And a related question, of course, is what the position of the Trump administration will be with respect to affirmative action. Back in 2003, Betsy DeVos opposed a Michigan law allowing affirmative action, saying at the time that, quote, race is irrelevant and should be irrelevant. President Trump himself has made contradictory statements on affirmative action, but most recently he has acknowledged that he generally does not support affirmative action programs. I think the other thing to keep in mind is that the nominee for Attorney General, Jeff Sessions, is on record as opposing affirmative action. So it seems unlikely that the Department of Justice in a Trump administration will support use of race in admissions decisions. And also keep in mind the question of how race can be used, if at all, in financial aid decisions. And that opposition is present amongst members of the Trump administration, even when race is only one part of a holistic assessment. Of course, on the minds of many is how the new Department of Education, and particularly the Office for Civil Rights, will deal with all the issues that arise under Title IX. John Burkowski is going to speak more on this in a few minutes. But I think it's safe to say that many of these issues are going to be re-examined and approached differently than they were under President Obama. For example, I think the role of colleges in the handling and adjudication of misconduct and sexual violence cases involving members of the campus community will be subject to further review and revision. How colleges and universities deal with transgender students, and indeed the whole LGBTQIA community. The Obama administration supported that community's rights more than any prior one. The question is, will a Trump administration undo that support? Betsy DeVos at her hearings didn't make clear what her views were on gender identity. Another issue, of course, is accessibility on campus, including web accessibility. And I would mention here, just as an aside, that Ms. DeVos showed during her confirmation hearings that she wasn't familiar with the Individuals with Disabilities Education Act. And while that is not necessarily germane to higher education, she did indicate or reiterate a kind of basic principle of hers and of what appears to be a principle of the Trump administration, namely that authority over many educational matters should be transferred from the federal government to state and local officials. So what we may see in a number of instances is, I think, a de-emphasis in the department's enforcement of existing regulations and sub-regulatory guidance, including things like Dear Colleague letters. Let me briefly mention two more topics which are not really within the province of the Department of Education, but which I think colleges and universities need to think about. First, a Trump administration will presumably cause a rebalancing of power on the National Labor Relations Board. In the past, the question of whether graduate students are employees for purposes of collective bargaining has changed depending on whether the Democrats or the Republicans are in the majority. In 2016, the board reversed itself for at least the third time, holding in a case involving Columbia University and the New School in New York that graduate students were employees for purposes of collective bargaining. The board had reversed, under President Obama, the 2004 decision in the Brown University case. And Brown had, of course, had said students at private universities, and remember the National Labor Relations Act only applies to private schools. Brown had said that graduate students were not able to unionize under the NLRA. 4 years earlier, however, had said that, but 4 years earlier, under President Clinton, in the NYU case, the board had permitted unionization. So a new board with a Republican majority could have a profound impact on private institutions in this area. The last thing I want to mention before I turn the program over is I wonder if a Trump victory coupled with a Republican-controlled Congress will reinvigorate efforts by individuals like Iowa Senator Chuck Grassley and others to tax college endowments. Grassley made a similar push to tax endowments back in 2007, 2008, just before endowments took a beating in the recession. So I think that it's certainly a topic that might be on the table, and one can only wonder, if that were to happen, what the implications might be for the costs of higher education, how institutions themselves would be able to fund scholarships for some of their students, and there's a whole range of questions that arise there. So let me now turn things over to Julie.
Thanks, Tom, and hello to everybody on the line.
I'm going to cover a little bit about the Trump transition on education, and I know that Tom's already touched a little bit about our presumptive education secretary, Betsy DeVos. But I'm going to give you a little bit of background and information about what we learned at the hearing, and then talk a little bit about how that's impacting the Department of Education's transition and what we might expect to see in the coming weeks and months ahead. So the Senate Health, Education, Labor, and Pensions, or the HELP Committee, held Ms. DeVos's confirmation hearing last Wednesday. At the hearing, Senate Republicans unanimously expressed some support for DeVos. They specifically were praising her for her work as a school choice advocate and as a student mentor. But on the other hand, the Senate Democrats were raising primarily two issues. One, they had concerns about potential conflicts of interest due to her investments in the education sector. And two, they were questioning her qualifications to be the Secretary of Education. Senate Democrats expressed a lot of concern about her background and were critical that she did not have experience having worked in the public schools. But while DeVos does not have a similar background to her predecessors, she isn't a newcomer to politics or to education. She had served as the chairwoman of the Michigan Republican Party in the 90s and early 2000s, and she supported her husband's run for Michigan governor against Jennifer Granholm, which was ultimately unsuccessful. She had led two nonprofits that spent millions supporting her policies for school choice, specifically around charters and vouchers around the country, and she's been active in the education advocacy community. What we learned at the hearing was that we know she cares deeply about school choice, and during the hearing she sort of doubled down on those views. So it's safe to say that if she's confirmed, we should anticipate that she will continue to support voucher and charter policies in the K-12 arena as secretary. But we learned, as Tom was alluding to, that very little with respect to her views on higher education. For one thing, we didn't hear about her personal views on Title IX and gender equity issues. However, she did state that sexual violence on campus is a problem, and she's committed to looking at the issues carefully from both the perspectives of victims and accused perpetrators. We also didn't hear much in response to questions from Senate Democrats about her views on the cost of college and how she might go about reducing student debt. And she did not respond to questions about whether she supports efforts to make college free for qualified students. Ms. DeVos also didn't commit to enforcing regulations intended to increase transparency and accountability for career training programs. Her consistent answer in the hearing to a lot of these questions was that she would look at the issues and she looked forward to working with the Congress to address them. So the next steps for the process for Ms. DeVos is that the confirmation process will continue through the Senate for the next week. Because of a small delay in DeVos's ethics paperwork and some questions that Senate Democrats had about her plans to address conflicts of interest, the HELP chairman, Lamar Alexander, delayed the committee's vote on DeVos's nomination for about a week to January 31st. Senator Alexander has stated that the delay is only to give committee members time to review her paperwork. And Democrats just very recently renewed their request for a second hearing, which they also had made mention of during the first hearing. But just late yesterday, Alexander declined this request. So while we wait the week, we can expect and have already started to see some continued lobbying by the left and some in the education community in an attempt to either delay or try to disrupt DeVos's confirmation. Whether any of this will be enough to derail or even delay her confirmation is yet to be seen, though to me, I think it seems unlikely. For one thing, Democrats don't have a clear path to voting down the nomination or to stopping a vote. The next step is for the committee to vote to move the nomination to the Senate, and even if the committee fails to act, the Senate has the authority to bring the nomination directly to the floor. And once the nomination is before the full Senate, it only requires a majority vote, and the Republicans have that with 52 senators. Finally, there's no longer a filibuster opportunity, as Democrats changed that rule 3 years ago in effort to confirm nominees by President Obama. So all this to say, there really isn't a clear path for Senate Democrats to stop DeVos's nomination without the help of at least a few Republican dissenters, and so far we haven't seen any evidence that anyone is willing to defect. The last thing I'll say on this is that rejections of cabinet appointments are very rare. So despite some controversy around DeVos's nomination, I think she will make it through. Unless, of course, the Trump administration or Senate Republicans get concerned about political pressure and decide to go in another direction, but I also think that's very unlikely. So now I'm going to talk a little bit about the transition underway at the U.S. Department of Education. So while DeVos would be brand new to the department, there's a number of key members of the department's transition team that have extensive experience there. In fact, 3 transition team members actually all served as Bush administration political appointees. All of those members of the transition team know the department, they know the staff, and they know how the department runs. And all work directly on higher education issues and understand the complexities of things like the Higher Education Act, the student aid programs, and the department's enforcement work. So in my estimate, the folks that are working on the transition team right now at the department are not the kinds of folks who would be advocating for shuttering it. Instead, I suspect that the transition team will probably be advocating for things like flexibility to states, colleges, and universities, and things like delivering education and complying with various laws. And I suspect they will likely support the removal of what they or the Trump administration may see as hyper-prescriptive regulations by the Obama administration. So while there's been much anticipation that a Trump team could mean relaxed enforcement in some areas, a reduction and also perhaps a reduction in compliance burden, it's my view, having worked at the department, that most of these efforts will probably take some time. For one thing, once the secretary is confirmed, the transition team and the secretary will need to focus efforts and much time and attention on hiring appointees and developing their agenda. And don't forget, historically speaking, a lot of issues in higher education can take a back seat to K through 12 issues, particularly in the first few months of an administration. So one thing to watch here is for who's getting appointed into the top jobs at the department. I provided a list of some of those here that have impact on higher education policy. What you should be looking for is whether some of those folks filling those jobs are coming from the K through 12 space, because if that's the case, they're going to be bringing that lens and that agenda with them, which may delay further developments in higher ed. But it's certainly possible we will see some change in the early months of the administration. I'm going to talk about that later. But for the most part, I would recommend that we need to be patient, and we may be waiting for some time before the team really ramps up and develops its platform. So now I'm going to turn it to John to talk a little bit about what we envision for the Office for Civil Rights.
Thanks, Julie. One of the key areas in the Department of Education that we all work with a lot is the Office for Civil Rights. And they've been with us for 51 years, charged with enforcing federal civil rights laws by recipients of federal funding, including probably all of the institutions represented on this call. Two things about the Office for Civil Rights that I think I want to highlight right at the beginning. We're talking about an agency of as of 2016, about 563 full-time equivalent employees in 12 offices nationwide. Most of those people are not in Washington, D.C., and most of those people are career civil servants. And so in terms of our day-to-day interactions with OCR, I think there is going to be a lot of continuity. On the other hand, the outgoing Assistant Secretary for Civil Rights, Catherine Lehman, worked very closely with the Obama administration, worked very closely with the Department of Justice, and set a very high profile for the agency and set some very aggressive policy positions. And as Tom indicated, and we'll talk about in more detail, I think some of those policy positions may change. As the main enforcer of federal civil rights laws in the education space, OCR covers really important issues for all of our institutions in dealing with students. All discrimination claims on the grounds of race, color, national origin, sex, disability, age can all be brought simply by sending a letter to the Office for Civil Rights. And the Office for Civil Rights, as I said, works very closely with the Department of Justice. Now, we don't have a nominee yet for Assistant Secretary for Civil Rights, But there is a nominee for Attorney General, Senator Sessions, and there is a nominee for the head of the Civil Rights Division of the Department of Justice, John Gore. Neither one of those individuals has an aggressive record in enforcing civil rights. In fact, John Gore has a long history of defending states in challenges to some of their election laws. And so I don't think we're going to get a nominee for Assistant Secretary who is likely to have a long track record of enforcing civil rights. When we talk about OCR, we have to remember that it all comes down to the threat of withholding federal funds. And OCR enforces its mandate through that threat, although it also can refer things to enforcement with the Department of Justice. And we saw more of that in the tail end of the Obama years with OCR and DOJ acting in conjunction, both in an enforcement capacity and in a policy capacity. OCR also has several other tools at its disposal. In 2009 to 2016, OCR issued 34 different policy documents. That was probably the most active period in terms of policy documents in the agency's history. It seems extremely unlikely that the new administration will match that pace. One thing to watch for, too, is that a number of those policy documents may be withdrawn, or, as happened in the Bush administration, there may be an announcement that they simply will not be enforced. That's something that's not happened yet, but I think we need to watch to see how these Dear Colleague letters are treated down the road. Another note, the complaint process. In the period from 2009 to 2016, there were more than 76,000 complaints filed with OCR, and 66,000 complaints were resolved during that period. That's an incredible level of enforcement activity. One thing one has to wonder about that is how much that was driven by the high profile set by OCR and the number of policy guidance documents that they kept putting out. My own suspicion is that OCR's high profile actually encouraged the number of complaints. And again, I think that high profile could well change in the new administration. On the other hand, these complaints, a number of these complaints are still pending, have not been resolved, and are going to have to be dealt with by OCR under new leadership. If you look historically, OCR's jurisdiction has continually expanded over time. And if you look at this chart, there are major civil rights pieces of legislation that have been in place for a long time that are under OCR's jurisdiction. And most of those statutes are unlikely to be undone. And so while there may be changes around the edges of some of these things, the fact that these laws are in place and have been on the books for many years, and the fact that there are a number of complaints already pending, mean that even if there is a slowdown in OCR enforcement, we are still going to have to deal with the regional offices nationwide in resolving these complaints and making sure that our institutions remain in compliance with these fundamental civil rights laws. I just wanted to show this graphic from a recent OCR report to the President, because it really highlights quite dramatically the increase in complaints that you see during the Obama administration. I think that was quite possibly driven by policy guidance. It's certainly been encouraged by the active enforcement of OCR. And I think it's clear from some of the few comments that have come out of the transition team about education, it's clear that there's a desire to try to rein in the level of activity from this agency and frankly, federal administrative agencies generally, but in particular in this arena. So what's the implication of that for us? Well, if you look at the staffing level of OCR historically compared to the level of complaints, you have a situation where we're going to inevitably continue to face slow investigations. In fact, I would hazard a guess that the pace of investigations under the new administration will slow down even more than it currently is. You have an understaffed agency, you have the highest rate of complaints ever, and one of the president's first actions, as we saw in the paper today, was to sign an executive order freezing hires. And so you've got an understaffed agency that has a huge number of complaints and is also facing a hiring freeze. So for those of us that have ongoing OCR investigations, I don't think we can expect any increase in the speed at which those are resolved, and that's going to be continue to be a challenge in dealing with OCR complaints. Another interesting note from this recent report of the outgoing Obama OCR leadership is that for the first time in many years, the largest number of complaints involved alleged discrimination on the basis of sex. If you look at similar data from previous years, almost always the largest number of complaints were based on discrimination on the basis of disability. And I think that reflects the huge amount of attention focused on sex discrimination, particularly sexual violence, preventing sexual assault and other forms of sexual violence on campus. And I think that is reflected in the large amount of guidance, the large amount of effort put into that issue by the administration. And I think that's reflected in turn in the complaints that were brought forward by individuals to the agency. So let's talk about a few particular areas in which OCR has been quite active and do a little, as Tom put it, dangerous tea leaf reading about where the new administration might or might not go on some of these key issues. First, let's talk about transgender students. This is an area where OCR, in their May 13th Dear Colleague letter, staked out the position that Title IX prohibits discrimination on the basis of gender identity. And that is a controversial position, but OCR adopted that position and began enforcing that position nationwide. Of course, in August, a federal district court enjoined OCR, and for that matter, the Department of Justice and the EEOC from enforcing that view of Title IX with respect to locker rooms, bathrooms, showers, and other facilities. And that litigation is ongoing. The injunction does not appear to affect the OCR's position with respect to gender stereotyping harassment. But with respect to access to facilities, the whole restroom controversy that we've seen taken up in state legislatures like North Carolina and others nationwide, that OCR's interpretation of that issue has been enjoined. In the meantime, of course, the Fourth Circuit took the exact opposite position from this district court in Texas. The Fourth Circuit ruled that it should defer to OCR's interpretation of sex to include gender identity, and then ruled that based in part on that deference, that Title IX did in fact prohibit discrimination on the basis of gender identity, and ruled that a transgender student should be able to have access to restroom facilities consistent with the student's gender identity. And it was only after this Fourth Circuit ruling actually, that the Department of Education and the Department of Justice released their guidance on this issue. That formal guidance was released after the Fourth Circuit endorsed what was OCR's previous informal interpretation in a letter that had been sent during the course of this dispute. So the issue before the Supreme Court is an interesting one. There are really two main issues. One, of course, is should the federal courts defer to agency interpretations that simply come in the form of a letter, that are very informal interpretations of a statute that is committed to their jurisdiction. The other issue, of course, is does Title IX, in fact, prohibit discrimination on the basis of gender identity? And it's interesting, the court has changed the briefing schedule in this Gloucester County case so that the respondent's brief is now due February 23rd, and then the school district, which is the petitioner and the defendant in the case, the school district, will have a reply brief due after that, and the case will probably be set for argument sometime in March or April. The implication of that, of course, is that that gives the Trump administration time to change position in the case. And many are speculating that that is a possibility. The nominee for Secretary of Education has a history of donating to groups that were opposed to same-sex marriage. Does not seem likely that she would support the Obama administration's position in this case. President Trump, it's harder to say. The Attorney General, again, his record on civil rights protections is not strong. So there's obviously a chance here in the coming months that there may be a change of position on this fundamental issue of how Title IX should be interpreted. Now, regardless of whether the administration changes position or not, however, it's going to be in the Supreme Court's hands ultimately to decide what Title IX means. There's a chance, of course, that the court might not do that in this particular case if the administration changes position. If the administration changes position, one option for the court would be to simply remand to the Fourth Circuit, to the lower courts, to determine whether they should, in fact, defer to the new administration's interpretation of Title IX. So a change in position could give the Supreme Court an opportunity to essentially dodge this issue. So I think that what happens first with the administration and then with the Supreme Court in this Gloucester case are going to be critical to what our responsibilities are going forward to accommodate transgender students, at least in terms of the requirements of federal law. Web accessibility. Web accessibility has been an issue also of growing importance in recent years. A Dear Colleague letter on this issue came out in 2010, and by 2016, there were literally hundreds of complaints coming in on web accessibility against educational institutions. There are also new regulations that are going to be forthcoming, and this is an area where I think we may not see a lot of change in the new administration. One of the early resolution agreements involved the Michigan Department of Education captioning of videos, and one of the big proponents of these complaints is a disability rights activist from Michigan, and there are some connections between those folks and the nominee for Secretary of Education. And so web accessibility may be an area where we don't see as much change as perhaps we will in some of these other areas. The resolution agreements, the key thing about the resolution agreements is that they're very difficult to implement and they can be costly. And so this is an area where I think we need to keep our attention and try to continue to be proactive at our institutions, because once a complaint is lodged, the control of the pace of change and that the institution has to undergo is given up to some degree. Tom talked earlier about the key race-conscious decision-making thing. I don't think I have a lot to add really on this. The guidance in 2011 that the Obama administration came out with obviously really encouraged institutions to take measures to promote diversity and laid out in some detail the ways in which that might be done. But it's quite possible that guidance could be withdrawn or changed. And if you look at the nominees so far in the new administration, you don't really see a notion that there will be strong proponents of affirmative action. And unfortunately, even though Fisher 2 was a victory for the University of Texas and for proponents of diversity in higher education, it still left in place a very demanding standard of strict scrutiny for race-conscious measures to meet. And I think it's quite likely, if you look at the record of Senator Sessions and Mr. Gore, that the Department of Justice and likely OCR as well will draw a harder line towards at least race-conscious efforts to promote diversity. Another area where I think we're likely to see some significant change is the area of sexual violence. If you look at this list, there's just been a huge amount of effort, guidance, dear colleague letters, Q&As, all kinds of efforts by OCR, by the White House Task Force over the last 5 or 6 years to really try to push institutions to do dramatically more to address sexual violence. There's 673 complaints involving the way institutions handled alleged sexual assault in 2016 alone, and there are hundreds of colleges and universities currently being investigated. How is OCR going to handle those ongoing investigations is an open question. I think it's quite likely that some of the interpretations in the various guidance documents will be changed. On the other hand, you have the same career investigators investigating these claims, and so it's going to be interesting to see how that plays out over time. Certainly, as I mentioned earlier, the rate of investigation, the rate at which new and pending investigations are handled is likely, if anything, to slow down. And of course, there are areas where the guidance may change. One obvious area where that could potentially change is the preponderance of evidence. That standard may be abandoned. As Tom indicated, FIRE has already called for that to be abandoned. Indeed, FIRE asked that the administration take the position that colleges and universities should get out of the business of investigating these complaints altogether. So we're going to have to watch to see closely what the new administration does on sexual violence, but it's definitely going to be something quite different than we've seen the last few years. With that, I'd like to turn it back over to Julie for some more discussion of what may happen with some of the Obama-era regulations.
Oh, there we are. Thanks, John. So at the 50,000-foot level, we know that there's been a lot of calls for the removal or elimination of a number of Obama regulations, including those in higher education. So I want to talk a little bit about what the process for that might be. There is a mechanism for Congress and the President to eliminate or nullify some rules, and that's the Congressional Review Act. It allows Congress to review rules that were just recently submitted within 60 legislative days for review and potentially for nullification, and that would be done through a joint resolution. The Congressional Review Service is right now estimating that that would pretty much cover rules submitted after June 13th of 2016. The problem with this mechanism is the CRA requires that rules to be nullified must be done through one joint resolution at a time. So this has only successfully been utilized once, while it's been attempted many times. 16 years ago, it was used to eliminate some OSHA regulations back in 2000. What's interesting is that the House is looking to expand this Congressional Review Act to provide an easier time to the administration to bundle regulations and repeal them. In November, the House passed this Midnight Rule Relief Act, and some have commented that it would be like taking a chainsaw into surgery. The idea here is that it would allow for multiple rules to be disposed through one joint resolution as opposed to one at a time. It passed the House in November and was received by the Senate Committee on Homeland Security and Government Affairs on January 5th. So it's yet to be seen whether the bill will get out of committee and whether the Senate will vote on it, and if so, whether it would then go to the President for signature. Without a doubt, if this legislation was enacted, it would be a bold move, but it certainly would allow President Trump to honor a number of his campaign promises, which were to do away with rules he felt were hyper-prescriptive. So I do think it's a possibility with a Republican-controlled Congress. How that might impact higher education regulations is that a number of those rules fall within the scope of the CRA. Those include the borrower defense rules, which were published October 28th, the teacher preparation rules, published October 12th, and state authorization for distance learning, published December 19th. Part of me wonders whether the Trump administration would use this sort of slash and burn approach to the Obama education rules, because it could leave the administration open to some criticism that it's removing protections intended for students and consumers. But with the potential expansion of the CRA through the amendment that the House had just passed and the potential for bundling the rules, I do think these three rules very well may get swept up in any sort of comprehensive rule repeal effort. So just to refresh ourselves on what those rules would be doing when they take effect July 1, the borrower defense regulations are essentially a consumer protection rule. They expand loan relief protection for borrowers who are unable to pay, and that's generally based on some sort of malfeasance from the school. They've expanded those claims to include substantial misrepresentation, breach of contract, and a judgment that's been issued against the school. Prior to the rules, borrowers were only able to assert a defense to repayment on the basis of intentional fraud or violation of state law. The regulations do a number of other things, such as requiring loan discharge disclosures from the school. They ban schools from requiring arbitration agreements, and they can impose penalties on schools that violate these rules. The other two rules that we mentioned are the state authorization regulations and teacher prep regulations. The teacher prep rules essentially are looking to build transparency and require some effectiveness metrics from states at the program level for those programs that prepare our nation's teachers. The state authorization regulations are sort of a second rule installation by the Obama administration, and these specifically govern distance learning programs or online programs that are operating in a state. We don't know for sure if any of these will survive, but again, if for any reason there's a bundled approach and that CRA expansion occurs, these do fall within the scope, so it's possible these could be eliminated pretty quickly. There are some rules that we're living with right now that may be tougher to unwind because they would fall outside the scope of the CRA. The first one is gainful employment rule, which became effective July 1, 2015. This rule imposes some transparency requirements around things like repayment rates and debt-to-earnings ratios, and then it sets debt-to-earnings accountability metrics for GE programs that programs have to be held accountable to. Remember, for better or worse, a lot of the Obama regulations, like GE, were undertaken in the name of consumer protection and intended to enhance accountability and transparency and try to reduce fraud, waste, and abuse. So taking a hatchet to these policies could potentially create some political risk, but many in higher education feel that these rules really need to go, and so there's a very high motivation to seeking some sort of repeal or change to the rules. But because they fall outside the scope of the CRA, what's really important here is that the Trump team will need to find another way to reduce these rules' impact. And that could come either through non-enforcement of the rules, seeking a legislative override, or some other sort of repeal effort. And I note that a legislative override here is perhaps more probable than it's been before because there's a Republican-controlled Congress, and many of those members are very sympathetic to the idea of unwinding the GE program. Another one that's maybe tougher to unwind, again, falls outside the scope of the CRA, are the VAWA and Clery regulations. Now, we really haven't heard a lot of motivation to try to remove these, but they have, these rules are the kinds of things that are often mentioned when higher education folks are talking about the burden on regulatory compliance. What's important here is that these rules were effective July 1, but they established a lot of requirements that we've seen in guidance from OCR on Title IX. And so even if, as John was talking about, even if OCR chooses not to enforce its guidance or eliminates those sub-regulatory guidance pieces that talk about a number of these topics, we should keep in mind that the VAWA and Clery regulations essentially codified a number of those, and that these would still stay on the books unless and until some sort of broader rule repeal or revision was undertaken by the Trump administration. Another thing we're watching is President Trump's plan to repeal DACA, or the Deferred Action for Childhood Arrivals policy. This was a policy that was implemented through an executive order, and it provides temporary protection from deportation of certain individuals who arrived in the country illegally but as children. It generally provides those folks an application process to seek work permits, attend school, and engage in our military service. Now, Trump campaigned on a promise that he would eliminate the program, and that campaign has resulted in a lot of concern from undocumented students, particularly those dreamers who are advocating or publicly speaking about immigration reform. Those students may now be worried that they could be exposed and potentially at risk to be deported if this policy is eliminated. This one has been a hard one to watch, and I'm feeling, as I'm trying to monitor this, like I may be getting a little bit of whiplash because the message has been changing. Very recently, the Trump team had been reported as claiming that the president would rescind this executive order in his first few days of office. But just on Sunday, President Trump's chief of staff hinted to reporters at Fox News that Trump is not really planning to repeal the DACA executive order right now, and instead is looking for a long-term solution. So as I was drafting these slides, I thought I knew where this was going, and now I don't. So this is one that we're going to be watching. Priebus wasn't making any commitments on this, but he did say that the president's looking to work with Senate and House Republicans. So this is just one that we're going to have to wait and see on. The last thing I want to cover is the Higher Education Act reauthorization. We know that reauthorization is really well overdue, and this is the law that governs eligibility and participation in the Title IV Student Aid Program, among many other things. There were a number of attempts in the last two Congresses to enact some piecemeal legislation to get reauthorization started. Those proposals generally focused on things like FAFSA simplification, that's the free application for federal student aid, financial aid counseling, flexible Pell Grants, and just reducing burden overall on higher education institutions. And there is a lot of motivation right now because of a bipartisan task force report highlighting the burden on higher education either through law or regulation. So I do think that this is probably poised to go. I know that the last Congress was actually very motivated in trying to accomplish some form of reauthorization in its term. But what happened is that the K-12 sort of sucked the oxygen out of the room, as it sometimes does, and the Congress really was focused on reauthorizing the No Child Left Behind Act. So now that that hurdle has been passed, I think once these hearings slow down, it's likely that a Republican Congress will get to work on this. And the real question is whether or not changes will occur through some sort of wholesale rewrite or piecemeal. The one last thing I will leave you with is there is some legislation that may be worth watching. As I said, the last two Congresses actually proposed a number of legislative pieces that would amend the HEA. The ones in the last Congress, most of them came from House, but there's one in particular highlighted at the bottom of the slide that came from the Senate that I think is maybe has some potential. It's the Financial Aid Simplification Transparency Act, or the FAST Act. I wouldn't be surprised if some components of these various bills essentially get combined into one larger bill, but then it's also possible that the Senate Help Committee and the House Committee that works on education issues may decide to take it piecemeal. So some of these may inform what HEA reauthorization looks like, but we also just have to wait and see. So with that, I'm going to quickly turn to Lisa on accreditation.
Thank you, Julie. So we will round this out with talking about accreditation. And while we currently are living in a politically polarizing time, accreditation may be the one area in which we actually have some bipartisan agreement. Unfortunately for the accrediting agencies, though, both Democrats and Republicans, as well as the executive and legislative branches, agree that our accreditation system needs to be improved and possibly completely overhauled. This attitude towards accreditation is referenced on this slide. This slide lays out some of the articles that have come out over the last 2 years, as well as some of the direct quotes from Obama administration ed officials, as well as Republican and Democratic lawmakers related to accreditation. Now, on the other hand, accreditors, while they may think that their critics are being too harsh, and also pointed out that potentially their critics do not fully understand what accreditation even is, the themes being heard about accreditation is that the process is flawed and that the accreditors are too lax. So this is definitely a tough time for accreditors. And to make matters worse, NACICI, which is the National Advisory Committee on Institutional Quality and Integrity, and this is the committee, by the way, that makes recommendations to the department regarding which accreditors should be recognized for purposes of their institutions receiving Title IV aid, NACICI has decided to talk tough. And in their meeting that they had this past June, NACICI made clear, and this is a quote, "There's a new sheriff in town," and they also stated, "This is not your grandfather's NACICI," end quote. So we're looking at a time that, if you're an accreditor, is troubling. And we're running short on time, so I won't go through some of those decisions, but the one that's the most well-known was the recommendation that ACICS, a 100-year-old accreditor, have their recognition revoked, which the department subsequently did, which has caused a plethora of issues for those ACICS-accredited schools. The ABA also suffered some scrutiny during that time. A lot of the institutions on this call are accredited by the Higher Learning Commission, and it's definitely worth note that the last time the Higher Learning Commission was before NACICI, they also received extreme criticism about the fact that NACICI felt they were not paying attention to student outcomes like graduation rates. And so we have seen an increase in the Higher Learning Commission about those types of things. So what do we think is going to happen in 2017? Well, if the accreditors are getting a bit crankier, it's because of all of the pressure on them, and this may mean that they will issue more sanctions. They have been charged with not being consistent in issuing sanctions and not issuing enough sanctions. So, for example, recently the Southern Association of Colleges and Schools, or SACS, at their last meeting, they put 10 institutions on probation, including 2 large public institutions. That is not the norm, and so we can expect that. On this slide, we list the top sort of hot spots based on schools that are HLC accredited who during 2016 were either put on probation or notice. So please check this out, because these are the areas that have been emphasized and have been the places where schools have gotten in trouble, not usually for just missing one, but for having multiple concerns related to these issues. So what else do we expect? We expect that accreditors are going to the extent they can, sidestep a little bit of the peer review process. And this is due to the fact that in April of 2016, the department sent accreditors a letter stating that they expect accreditors to provide more student protection. And so, for example, the Higher Learning Commission in August issued a new policy, and under this policy, their president, if she deems necessary, may call for special monitoring of a school as opposed to waiting for an accreditation visit. Also, the HLC president, after consultation with the HLC Board of Trustees, may now give schools what's called a public designation, and there's two kinds. You can have a designation of being in financial distress, which for a public institution could be triggered if you have poor state funding, or if you're placed on heightened cash monitoring could be another reason for that designation. You also could be placed on designation if you're under governmental investigation. It doesn't matter if these allegations have been confirmed or not, but if you're under any type of state or federal investigation, you could receive this designation. These designations will mean for a school that's on this more reports, more visits, and an inability for your school to make any sort of substantive changes. So we're going to be wrapping this up. The thing to know is that in terms of accreditation, there's some bills pending from the Democrats that probably aren't going to get a lot of weight. But as for Republicans, Marco Rubio has long been wanting to make accreditation more innovative. So we may see paths for innovation in terms of accreditation. Instead of accreditation, innovation authorizers. If you think about things like a coding boot camp, perhaps if they could meet the innovation authorization, then they would be eligible for Title IV funding. If there is any change in accreditation, it's going to come when HEA is reauthorized. This can mean a variety of things that we have listed on this slide, but in the interest of time, we're going to move forward and wrap it up because we do try to end these on time. So here's a list of our recommendations, which we won't go through, but please stay vigilant and please pay attention to what's happening because we really are in an ever-changing regulatory environment. And so we are going to wrap this up, but we are going to stay on for a few questions if you so choose. But otherwise, if you need to go, we certainly understand, and we want to thank you for all of those who've joined our program today. We hope the information provided was helpful for you and your organization. If you have not already done so, would you please click on the survey icon at the bottom of your screen to complete our short survey. Your feedback assists us in providing quality future programs. As a reminder, this program has been approved for Colorado, Illinois, Iowa, Kansas, Missouri, Nebraska, Tennessee, Texas, and Wisconsin continuing legal education credits. A recording of the webcast will be available tomorrow for watching and sharing. Once available, a link to the recording will be emailed to you along with a certificate of attendance. This should be within about 2 weeks. By the way, our next webinar is on Tuesday, February 28th regarding technology transfer in higher education. And if you did submit a question, we will be responding to those questions instead of now. We will get back to you via email. Thank you, and this concludes our webinar.